Hello, and thank you for joining Mayor Brown's webinar today, Benefits and Compensation University, Employment and Benefits Issues in International M&A. This is the second of 4 webinars in our Benefits and Compensation University 2022 series. My name is Stephanie Vasconcelos, and I'm happy to introduce and moderate today's program. I'm a partner in Mayor Brown's Chicago office and a member of the firm's Employment and Benefits practice. Joining me today are my employment and benefits partners, Giles Bywater in our London office, Eilini Fidelis in São Paulo, Julian Auer in Paris, Hagen Kokeritz and Guido Zeppenfeld in Frankfurt, though Hagen is actually here in Chicago today, and Hong Tran in Hong Kong. Before we begin, I have to do a little reading to cover a few of our administrative matters. So if you're applying for CLE credit, we will provide an alphanumeric code during the presentation. Please record this code on the CLE affirmation form. This can be found in the connection details email that we sent you yesterday. This form will also be emailed to you within the next day or 2 following our program. The email will also include links to a recording of today's program and to an evaluation form. The evaluation form will be found in the same file as the CLE form. Even if you are not applying for CLE credit, please complete the evaluation form so that we may continue to provide meaningful content. If you have any questions during the presentation, I invite you to let us know via the Q&A feature at the bottom of your screen, where you can type your question into the Q&A box. We will do our best to address your questions either live or sometime after today's program. So with that, let's begin. I'm really delighted to be joined by my colleagues in a variety of jurisdictions today, and we're going to talk about several different things. Our rough agenda is laid out here. Much of the structure will be discussing pension liabilities and the impact of pensions on transaction structure and how you deal with pensions through reps and warranties. Finally, we'll touch a little bit on HR due diligence and transactions with a particular focus on how ESG issues and the rise of ESG questions and concerns are affecting the way folks do diligence on transactions. So with that, I think we'll jump ahead to slide 5. I do want to make one note before we kick off. We do have a number of slides here that have kind of detailed thoughts and comments from our colleagues in all of the different jurisdictions. We're not going to go through all of those today. We'll sit on these slides, but you will get a copy of the slides that you'll be able to download and see if you have questions about what Eilini said about Brazil. Anything that you hear about today, you should see documented on the slides later. So with that, let's talk first about the impact of pension liabilities on purchase price. In the US, I'd say pension liabilities can be a real issue, but defined benefit pensions and multi-employer pension plans are something that we don't see particularly often anymore. I get the sense that in other jurisdictions, they are much more common, and therefore you're being asked to deal with pension liabilities much more regularly. Guido, maybe you could kick us off on talking about these sorts of issues in Germany.
Thanks, Stephanie. Of course, yes. Well, in Germany, I would say it's typically pension liabilities very often play a role in purchase price discussions because it's just as you said, Stephanie. It's different in Germany. Historically, DB pension schemes have been dominating in a wide variety. Maybe only over the last 2 decades or so that the pension de-risking gradually is happening in the ways like transferring to DC schemes. So we've got a funding issue, and the background is that German company pension law is pretty complex in terms of legal basis for pension commitments. We've got a variety of those, and we've got a variety of funding mechanisms and combination of those mechanisms, like direct promises, retirement funds, support funds, pension funds, direct insurances, or contractual trust arrangements. So all of that comes to funding. So the real issue, there are two key issues here. First is the determination of the actual value of the pension liabilities of a German M&A transaction, and the other one is, of course, the determination of the funding status of the pension scheme. As I said, well, in terms of determination of the actual value, the important thing to note is that first of all, under German law, the employer remains liable or the primary debtor of all pension liabilities, regardless of the funding mechanisms. That's a principle of German employment law. The other one is that if you look in the balance sheets, be it German tax or commercial balance sheets, or even under US GAAP, IFRS, or so on, it doesn't really reflect the real pension liability value. So that's a true issue where legal due diligence needs to be done for the pension schemes. And it's very tricky to comply actually with the legal framework and with the evolving case law when it comes to evaluation of actual pension liability. Particularly, this is the case when we're looking at targets, for example, in an M&A scenario where there have been historically changes to pension schemes. There might be things, a lot of pension liabilities, which are not reflected in the balance sheets and actually not the basis for the actuarial evaluations. So that's an issue. And some of the points you would need to look at in order to determine the actual value of the pension liabilities are things like anti-discrimination or equal treatment, operational customs. All of those can give rise to pension liabilities, which are not reflected, as I said, on the balance sheets. Others are invalid payoffs or waivers of pensions, invalid changes to the or closures of pension schemes, very often an issue here. Or under German law, you need to adjust pensions to retirees regularly, so every 3 years, and very often this hasn't been done properly, so that would give rise to pension liabilities not really reflected. So all of that comes into play when we're talking about determining the actual value of the pension liabilities. Now, the other issue, obviously, is the determination of the funding status. As I said, DB pension schemes have been very common in Germany historically. And if you look into the DAX 40 German companies, they've got a pension liability of more than half a trillion euros. And the funding ratio at the end of last year has been 72%. So that's the good news. The bad news that this has been at the end of last year. So, and if you look into what happened to the capital markets and to the interest rates this year, this is going to be decreasing. And more or less, I mean, we've got a strong Mittelstand, German Mittelstand in Germany. So not actually DAX 40 companies, which typically and historically have a much lower funding ratio. There are other issues when it comes to funding, to the funding statutes, which are mortgaging or disposal of funding assets, or the transferability of funding assets, which need to be considered. So all of that comes into the pension, or needs to be reflected in the pension due diligence, and very often plays a huge role in purchase price discussions, be it in indemnities or purchase price adjustment clauses. Sorry, I took up a long time, but it's complex in Germany, that one.
It sounds incredibly complex and a little intimidating. Julian, would the same be the case in France, or what are we dealing with there?
Thank you, Stephanie. For France, it's a bit less complicated than in Germany. You know, in France, the pension system is based on the pay-as-you-go principle, which means as opposed to the market capitalization. Concretely, it means that every month the employer needs to pay out and to withhold from the employee salary a certain amount of contributions that are defined, and he has to pay this contribution to two statutory funds or schemes which are the basis scheme, what we call the régime de base, and the complementary scheme, which is the régime complémentaire. This is the main part of the pension liabilities in France. So what does this mean in a M&A context? First of all, it means that pension liabilities resulting from this statutory scheme do not impact the purchase price. You know exactly what you have to pay every month. Okay, so this is not an issue normally. It means that it remains a few situations where the liabilities can come over. There are four main situations. Defined benefit schemes, which are quite rare now in France, because they consider that it was really, really expensive for the company, and then they restricted let's say, the possibility to have this kind of schemes in France. You have the defined contribution schemes. You know what it is. You have what we call PERCO, which is a company retirement saving plan where employees can save, either cash payments or days off in this plan, so that when they retire, they can have a pension to be paid to them. And maybe the most important, you have the retirement indemnities. Every employee, when they retire, they are entitled by law to a retirement indemnities, and this could be a huge amount of money. So in the frame of your due diligence, this leads to tackle two main issues. First of all, determine what whether what I call the non-statutory schemes comply with certain requirements. The non-statutory scheme that I mentioned to you, they can be implemented and benefits from tax and social security exemptions. But for this, they need to comply with certain criteria, such as being collective, being set up from a certain way, a certain level of contributions, be registered with the labor authorities, and so on. So in the due diligence, what the buyer will need to determine is whether or not this statutory scheme has been implemented compliantly, to avoid to be reassessed afterwards by the social security authorities or tax authorities, for instance. Second issues, you have to determine the actual value of the pension liabilities, and that pertain to the four situations that I mentioned to you. It is quite easy for defined contribution scheme or company saving plans schemes. The buyer has just to obtain precise and accurate information about what he has in the accounts. So what needs to be paid in the case of defined contribution schemes, and what is in the account of the employee in the case of the company saving plans. It's quite easy. It's not so easy for the defined benefit schemes. Even though they are rare, it happens that they have some that has been provided in the companies for top management, and then you have to go through actuarial providers to determine what could be the liabilities in the future. It is exactly the same for the retirement indemnities. It could be a huge amount of money, and you need to involve actuarial provider to determine what could be your liabilities when all the employees present at the time of the transaction will retire. So all of this impact, of course, the purchase price.
That makes sense. It does seem at least slightly more straightforward than what's going on in Germany, but it's still a fairly complicated scheme. So I suppose next we'll turn to Giles, and he can tell us how about in the UK.
Thanks, Stephanie. I think we're probably more at the Germany end of the scale than France, but let's see. The starting point in the UK is that the UK state pension is not generous. It provides a lower level of pension than many other countries. For example, France, as Julianne has just explained. This means that employment-related pension savings are an important source of income for pensioners in the UK. The UK government has recognised the importance of employment-related pension savings in the automatic enrolment laws that it introduced about 10 years ago. Under these laws, employers are required to automatically enrol into a pension scheme all employees who are aged between 22 and state pension age, which is about 65 in the UK. By automatically enrol, we mean the employer has to automatically make the employee an active member of the scheme, giving them the opportunity to make pension savings. The pension scheme which the employer provides has to meet certain minimum quality criteria. If the scheme provides defined contribution DC benefits, there are minimum contributions which have to be paid into the scheme. If it is a defined benefit DB scheme, there are minimum benefits which must be provided by the scheme to its members. As a result of these automatic enrolment requirements, a buyer looking to acquire a UK company should expect that it will have some form of pension scheme which needs to be considered as part of the due diligence process. If the target in an M&A transaction has a scheme which provides just DC benefits, the pension liabilities are unlikely to be material to a buyer. However, if the target has a DB, defined benefit scheme, the pension liabilities can be very significant and will need to be reflected in the purchase price or maybe in the transaction structure. To help you put this DB scheme issue into context, in the private sector in the UK, most employers now provide DC, defined contribution pension schemes. That's not surprising really, because they have much less risk attached to them for employers than DB schemes. But up until the 1990s, many UK employers did provide defined benefit schemes. This is a feature of social history in the UK at a time when employees often worked just for one employer throughout the whole of their careers. So many of those DB schemes, those historic DB schemes, have since been closed. So there are no longer any pensions being earned by current employees, but those old DB schemes, those historic DB schemes, still need to pay pensions which have been earned prior to closure. So the target, if the target in an M&A transaction has got a DB scheme, it may be that it's the historic pension liabilities which are more material than the future pension liabilities. There's a lot of UK law which focuses on getting employers to pay for historic pension liabilities for DB schemes. And there's a UK pensions regulator which monitors compliance and has powers, strong powers, to take enforcement action. In particular, if a target is being disposed of by a corporate group and as a result will cease to be involved in that corporate group's defined benefit pension scheme, this is likely to trigger an obligation for the target to pay into the scheme its share of the funding deficit. That's referred to as a Section 75 debt. You may have heard that expression. When working out a Section 75 debt, the scheme's deficit is calculated by reference to the cost of securing the scheme's liabilities with an insurance company, which is the most expensive measure of a deficit. And it's likely to be higher than the deficit amount used in the company accounts, for example. So when presented with pension figures as part of an M&A transaction, one important thing for the buyer to know is the basis on which those figures have been calculated. A Section 75 debt can be substantial. It's likely to be the subject of a good deal of legal and actuarial focus during the negotiation of the M&A transaction.
This sounds somewhat similar to concepts in the US where, defined contribution plans are certainly the trend now, but you have frozen defined benefit plans that could still have significant liabilities. So I certainly understand that concept. Anything more to add, or should we turn to Eileen for Brazil?
No, on to Brazil, I think.
All right.
Thank you, Giles. Thank you, Stephanie. In Brazil, pension liabilities that impact purchase price of M&A transactions are related to two topics. First, the mandatory Social Security contributions carried out on a monthly basis based on employees' salary. And second, liabilities related to complementary pension schemes that companies grant to their employees, which is similar to the scenario observed in other jurisdictions. So this complementary pension is not mandatory, but it's common in Brazil. In the context of the transaction, it's important to verify the salary's compliance with the mandatory contribution. It's mandatory by law, of course, and execute an actuarial and legal assessment of the pension schemes adopted by the target to determine the actual value of the pension liabilities. It's important to highlight that once the employer is granting this complementary pension, what is this benefit, the employer is not allowed to make any detrimental changes. So that's the reason it's important to determine the actual value of this benefit in the context of the transaction. But I think that Brazil is less complicated than Europe and the US.
It sounds like it, and maybe now we can compare it to Hong Kong.
Thanks, Stephanie. In Hong Kong, pension or retirement scheme arrangements do not usually affect the purchase price in an M&A transaction. They may do if the seller operates an also scheme, so also short for occupational retirement schemes ordinance. But more often than not, the employer will operate an MPF scheme, so a mandatory provident fund scheme. So in Hong Kong, we have two types of schemes. We have an MPF scheme, which are DC schemes, so pretty straightforward, like in most of the other jurisdictions we just heard from. And we also have schemes, which may be DC and DB schemes. If an employer or the seller operates an MPF scheme, that's pretty straightforward. Regardless of whether or not the business is sold as a share transfer or an asset transfer, there isn't much that needs to be done in terms of dealing with MPF in the SPA. There is no ability to transfer an MPF scheme to a purchaser, but what will happen is the purchaser will just set up their own MPF scheme and enroll the transferring employees into the MPF scheme. Regarding also in a business transfer, it's possible that the benefits may become immediately payable from the occupational retirement scheme in which the employees are participating. In order to ensure continuity of provision of retirement benefits, the accrued benefits of the employees will need to be transferred to the buyer's scheme. This may, depending on the terms of the retirement scheme, require the consent of the employees. And if an employee's consent is required, then it's possible to make the offer of re-employment by the buyer conditional upon the employee agreeing to transfer his or her accrued benefits to the buyer scheme. So where there is complexity, and I will say that this doesn't arise all that often and quite infrequently, is where there is an also scheme, and where the also scheme, where the seller is selling a business of that participates in a group scheme. And what happens is after the sale, the company that's being sold will need to be carved out of that group scheme, and so there's some complexity in relation to that. But in terms of also, the general approach will be in relation to a defined contribution scheme, the amount which the purchaser will be looking to have transferred should be the full value of the employer's account and the member's account in respect of each transferring employee or each transferring member. And in relation to a DB scheme, the purchaser will be seeking to have an amount transferred calculated by reference to actuarial assumptions in relation to future salary increases and taking account of the amount required to fund past service benefits for the transferring members into the new scheme. So that's where the complexity may arise. So actually, I'll give you another example of possible complexities. In addition to that, there may be further complications if the scheme is in surplus or deficit, for example, where the surplus in the scheme has been used to reduce contributions payable by the company being acquired, and the manner of calculation of the purchase price for that company has been calculated by reference to a multiple of profits, which will, of course, have been increased due to the reduction in the contribution to the retirement schemes. Then the purchaser should seek to obtain the appropriate part of the surplus within the scheme. If the scheme's in deficit, then the purchaser should generally either seek further funding from the seller or renegotiate the purchase price accordingly. So it's complicated, but the good news is that there are more MPF schemes around than also schemes.
So, you started that out with it's not that complicated and ended it with, well, it's kind of complicated and here are all the things to negotiate. So I'll be interested to see how you answer the follow-up questions. If we could jump to slide 15, and I know we've talked a lot about the first question, but I think that kind of set the stage for the importance that pensions have in transactions. My next question really is for you, and I think we can just go in the same order, so continue to jump in. Is there any way to handle this other than perhaps, indemnities or purchase price adjustments, or are there other ways to work with significant pension liabilities? Are there workarounds? Are they severable? Are there transaction structures that are better or worse? Or is this all just very bespoke and something that you work with your clients to handle the individual details on any given transaction? So Guido, I'll start with you.
Thanks. Well, apologies for Germany being so complicated, but I guess as a lawyer, I'm quite grateful for that. So on the transaction structure, I mean, we've been discussing purchase price impact of pension liabilities, and that obviously dovetails with the question of whether transaction structures matter, because obviously in an M&A scenario, the seller wants to maximize the purchase price and buyer doesn't want to assume all pension liabilities. And therefore, in German M&A scenarios, very often pension play a large role on the transaction structure, because obviously, it depends on can you separate can you separate the pension liabilities of retirees or the working population or past or future service, so as to in a transaction, so as to have an impact on purchase price and make probably for a seller the sold company more attractive. So a couple of principles for our audience to take away here. First of all, regarding the working population, so current pension liabilities versus vis-a-vis current employees, stock transfer and asset transfer, this plays a huge role in a stock transfer transaction. The principle is that all pension liabilities transfer to the buyer or the carved out company or the divested company, what have you, in a transaction structure. And this applies to past and future service. So workarounds for that one in a stock transfer are limited. One could think about assumption of debt, for example, but that requires the individual consent of the pension beneficiaries. So it's not really a very practical option. In an asset transfer, typically all pension liabilities vis-a-vis the working population would transfer, except for non-regular employees, so for example, board members. But the good news is in an asset transfer, pension liabilities vis-a-vis the retirees or former employees will not transfer to the seller. So the first question really is a stock transfer or an asset transfer scenario really helpful for achieving the envisaged results of a transaction. The second group of principles will apply to former employees, including retirees. Again, in a stock transfer scenario, we're going to have all pension liabilities regarding former employees to be transferred to the buyer. Workarounds in practice are typically only if we have a kind of a pre-closing spin-off or pre-closing carve-out of those pension liabilities. On the other hand, as I said, if we go for an asset transfer, and that could be a pre-closing in a share transaction, a pre-closing carve-out done by an asset deal, which would help because, as I said, the pension liabilities vis-a-vis the former employees would then remain with the seller. So what happens if all of those principles are not really changing the transaction structures, which is driven by tax reasons or what have you, and operational reasons, strategic reasons. So there are a couple of workarounds which we typically advise our clients upon when it comes to, okay, pension liabilities are transferring, but still we want to exclude or minimize the financial burden on the buyer. And those solutions are a bit complex, and I don't want to, obviously not going into detail on that, but just a couple of them. One is a collateral promise, which would constitute a direct claim of the beneficiaries vis-a-vis the seller. So the pension liabilities transfer to the buyer, but still the beneficiaries would have a second debtor, which is the seller. This could have an impact on the purchase price, obviously. Another alternative is a contractual undertaking, or in fact, an indemnification, which means that the buyer would still remain the debtor of the pension liabilities, but obviously the seller will indemnify him. There are combined approaches which typically are used in practice here, or we're talking about a real outsourcing of pension liabilities, for example, by funding it. If the seller chooses to fund those pension liabilities by a contractual trust arrangement, this could help in order to alleviate not the fact that legally the buyer will become the debtor of the pension liabilities, but alleviate the financial and economic burden on the target. So again, as I said, it plays a huge role in transaction structures in Germany. That's it.
My takeaway is to contact Guido if I run into any pension issues in Germany.
Yeah, that should be anyone's takeaway from that one.
All right, I'll pass to Julianne and then Giles and Eileen and so on.
Yeah, thank you, Stephanie. I will try to make it clear as soon as far as I can. The same, distinction apply for France as the Germany. The distinction between share deal, asset deal, and TP transfer, which TP transfer and asset deal are treated the same way. Share deal is quite simple because there is no change of employer. Only the shareholder is changing. So all the liabilities for sure will transfer, even though the term transfer is not the most appropriate, but they will continue as they are towards the employees, the active employees, but also the retirees. Regarding retirees, the only burden will be in case of defined benefit scheme, which, as I mentioned to you, is quite rare now in France. So all of this will transfer, and of course the buyer will be the buyer, so the new shareholder will be indirectly impacted. There's a distinction between the past liabilities and the future one. The past, no problem. The future, again, the buyer will be at the cost, but there is a but. He has the possibility to mitigate the pension liabilities by ending the schemes. So it will depend on how the schemes have been initially set up. But if it is, for instance, through collective bargaining agreement, he will have to renegotiate with the unions or the employee representative to determine the new conditions of the scheme or a proper period to end the scheme at all. And if it is if the scheme has been implemented unilaterally, then we'll have the possibility to denounce the scheme by formally inform all the employees concerned, the employee representative as well, and to respect a reasonable notice. So this is for the share deal. For the asset deal, again, the principle is quite clear. All the liabilities transfer, but there is two reservations. First of all, the liabilities or the schemes that have been transferred could be ended. As I just mentioned with the share deal, you can either denounce a collective bargaining agreement or a unilateral scheme that implemented the liabilities. Second reservation, the seller is accountable of all liabilities that born before the transaction, meaning that the buyer can ask for the reimbursement or compensation of any liabilities it assumes the cost of on behalf of the seller. The conclusion of that is that it is the buyer burden to ensure that all the liabilities borne before the transaction are determined as precisely as possible in order to properly be indemnified by the seller if at the end he needs to assume the cost of any pension liabilities. I try to make it as clear as possible.
Thanks, Julianne. I'll pick it up from a UK perspective, and I think the good news is that it's pretty similar to Germany and France, the position in the UK as regards transaction structure. transaction structure will impact the pension liabilities which are assumed by the buyer. So if we turn that around, if there are, for example, material defined benefit pension liabilities in relation to a particular M&A transaction, it may be that the transaction can be structured specifically to reflect where those parties have agreed the pension liabilities should sit. And if it can't be structured specifically, then we can use indemnities to get to the right place. There are, like France and Germany, two particular structures that are used for UK company deals. We've got the share sale and the asset sale or duty transfer, two ways of calling the same thing. Looking at each of those two in turn, for a share sale, the historic pension liabilities will usually stay with the target after the purchase is completed. And as we've already discussed, this is a key issue if it's a defined benefit scheme involved. The historic pension liabilities in that situation can be significant. And if there's a Section 75 debt, which we talked about earlier, this in particular will need to be discussed, and there are ways of severing that debt, but there are processes which would need to be complied with. As regards future pension liabilities on a share sale, the target company will stay as the employer, and the same employment contract terms will remain in place between the target and its employees. And that includes terms in relation to pensions. Sorry, just very quickly, I was pausing to take breath. The targets, the target's contractual obligations, again, under a share sale will continue beyond completion. On an asset sale, it is very straightforward. I'll just touch on that very quickly. Historic pension liabilities on an asset sale or TUPE transfer, they will usually remain with the seller in the UK. For future pension liabilities, under TUPE, the terms of employment of the buyer will transfer, of the seller will transfer to the buyer. But there is an exclusion under UK law in relation to occupational pension schemes. So you don't have to match, for example, DB schemes following a TUPE transfer. Any contractual obligations in relation to personal pension schemes do still have to transfer. That's different to occupational pension schemes. And the automatic enrolment requirements, which I talked about earlier on, they will apply to the buyer after the transaction has been completed. So that's the UK perspective.
Thank you, Giles. In Brazil, it's less complicated because Brazilian labor law provides that all rights and obligations related to the seller are transferred to the buyer. It's called labor succession, which include the seller's obligations with respect to pension schemes, mandatory by law or complementary pension schemes. So it's common, as other jurisdictions, to have clauses in the SPA regarding the obligations that will be assumed by the buyer and the administrative procedures that will be adopted in regarding to pension schemes as from the transaction close date. Of course, we have the indemnification clauses as other jurisdictions, but what we could do besides that, in addition to that clause. So in Brazil, it's common to consider three possibilities that's provided by regulatory law and applicable in labor and employment relationship. First, withdrawal of the pension scheme sponsorship. The second one is the liquidation of the pension scheme. And the third, transfer of the pension scheme management. It's common to have this negotiation of these three possibilities before the closing date. And then, of course, the SPA will provide clauses with what is negotiated by the parties and the indemnification and all the other obligations by the parts. But it's simple in Brazil because regarding all the benefits, including pension plans, we have this phenomenon of labor succession. So that's all for Brazil. So what about Hong Kong, please?
Thanks, Alina. At Hong Kong, pension retirement schemes are not usually a driver of M&A structure. Most employers have MPF, which are DC, which is a sort of a DC scheme, not sort of, they are DC schemes. So they don't typically drive the structure of an M&A. There'll be other aspects that drive the structure of an M&A transaction. If there's an also scheme involved, which isn't common, but if there is an also scheme involved, then you need to deal with in the SPA the transfer of the accrued benefits. So then you're looking at bespoke terms on transferring those benefits, valuation and adjustments and things like that. But that's, I mean, that's not common.
All right, we ended on the easy one. Okay, so I know we only have about 20 minutes left. So our next topic, I'll jump right into. This is on reps and warranties, and in particular on pensions, which is the topic we've been discussing. So in the US, when I see a pension plan, excuse me, is involved in a transaction, we expect a fairly standard but comprehensive suite of representation. So not only that, you know, the pension plan has been in compliance with law, it's been operated in accordance with its terms, but also, you know, representations about maybe its funding levels, or that there haven't been prohibited transactions, that there's not litigation relating to the plan. So perhaps you could each spend a little time talking about any unusual or unique reps and warranties that you'd expect above and beyond maybe those standard pieces, or maybe you'll tell me, no, it's really just kind of some standard basic reps regarding the pension plan. And this time, Eileen, I'll start with you.
Thank you, Stephanie. In Brazil, regarding pension schemes, the clauses generally provides that the seller has complied with some aspects that include it's standard to have these 4 conditions. 1, provision related to the fact that the pension scheme has been established and maintained in accordance with its terms and in compliance with the applicable law and the regulation. The second one is that all material contributions, premiums, payments have been made within the time periods prescribed by the terms of the pension scheme, applicable law and regulation. The third, the pension scheme is not under investigation by any relevant governmental authority. In Brazil, the main authority that government this kind of pension scheme, this benefit, is called PREVIC in Portuguese language, PREVIC. So it's important to have this condition in the clause. And the 4 is that the legal and the regulatory obligations regarding solvency, liquid, financial, and actuarial balance are fulfilled. So in summary, the standard clause is the clause that generally provides these 4 conditions. The seller will say that he is in compliance with these 4 conditions to the buyer. And as I explained before, the buyer will be the labor successor and will receive this standard clause.
Thank you. Giles, Julian, Hagen, is that typical across your jurisdictions?
Yeah, in the UK, a key purpose of reps and warranties is to encourage the seller to disclose to the buyer full information about the pension liabilities, so that appropriate arrangements can be agreed between them, for example, an adjustment to the purchase price or indemnity protection. Reps and warranties are a bit less about providing a remedy for an aggrieved buyer or disappointed buyer. Just to give you a couple of examples of some typical reps and warranties. No past or present participation, there's been no past or present participation by the target in any DB pension schemes or in any pension schemes other than those disclosed to the buyer. That's a really important one for us. Even if the target had ceased to participate in a DB scheme in the past, there can still be residual pension liabilities. The buyer needs to know about all schemes in which the target has ever participated, and that warranty will flush out that information. We need copies of all the scheme documents and make sure they're provided and reviewed by the buyer so that we can check what the benefits are, this key point, how much they're going to cost, and also the other terms of the scheme, where the balance of the powers sit between the trustees of the scheme and the employer. If there's a breach of a rep or a warranty, the usual remedy in the UK for the buyer would be damages for breach. To be successful with that type of claim, the buyer has got to prove the breach and also financial loss suffered by the buyer as a result of the breach. So it's quite a high bar to get over. And if a warranty has been given by the seller with a knowledge qualifier, so far as the seller is aware, this makes a successful claim by the buyer even more difficult. By contrast, if you're claiming under an indemnity, if a buyer has been successful in negotiating an indemnity in relation to a particular issue, then it's much easier to make a successful claim for breach than for breach of a rep or a warranty. But of course, with an indemnity, the associated risk is what's the financial strength of the entity giving the indemnity when you want to rely on it in years to come. Will it still have financial strength? So those are some of the key points in the UK.
For France, thank you, Giles. For France, representation and warranties are like in the UK. Are a main driver, because when you're on the buyer side, the game is to have the largest warranties as possible. It's usually very long sentences with a lot of commas, and you have to cover everything. So to give you some examples, in France, the representation and warranties usually covers improper disclosure by the seller of existing non-mandatory pension scheme and or of its beneficiaries. So DB schemes, DC schemes, you should disclose everything. If you do not disclose everything, this is for you. It covers as well improper disclosure of any individual commitment regarding retirement liabilities. I'm talking about golden parachute in case of retirement, for instance. It covers non-compliant withholding of the mandatory pension schemes contributions. If, for instance, you did not withhold the correct amount, then you could be subject, or the buyer could be subject to a reassessment over the past 3 years, and then this is covered as well in the rep warranties. Last thing that is usually covered is any undue benefit from tax and social security exemptions. As I mentioned to you, some pension schemes, DC or DB schemes, could be implemented in a way that allow the employer to benefit from tax and social security exemptions. Of course, if you did not do it compliantly, then there's a risk again of reassessment by the social security authorities. And then this is something that is covered in the rep warranties. It is usually said that the seller represent that he implemented all the schemes in a compliant way as per French law. And it's quite quick, but very efficient. So as a consequence, it is not unusual for the seller, because of the larger clause, it is not unusual for the seller to subscribe WNI insurance to cover for losses arising from any breach of the rep warranties. Again, I don't know how it is in Germany.
Yeah, thank you, Julian. So it's fairly similar. R&W clauses on pensions are fairly sophisticated in Germany compared to France. Probably we look at the same extent. And coming back to your question, Stephanie, from the beginning, I think the content will be pretty much the same across the countries. There are certain specific issues that each country looks at. And I think in Germany, there are a few that we should mention here. One is certainly a representation warranty regarding proper closures and amendments to pension plans, because there are certain formal requirements that need to be met, and also substantive requirements. If those are not met, certainly any past closures of pension plans would be ineffective, and employees who joined after the closure would have built up and accrued pension entitlements. So that's typically a big issue. And as we look at very often historic information that may be 20, 30 years old, sellers may not even be able to disclose everything in this regard. A second important point, it goes back to what Guido has mentioned. It's the obligation under German law for employers to regularly review and increase pensions and payment. So that needs to be done every 3 years. And in the current environment with a high inflation, we in fact see clients that are faced with increases of 10 or even more % of ongoing pension payments per year. So we talk about significant amounts. And if such pension adjustments have not been done properly in the past, there's an obligation to do basically backlog adjustments. So very significant liabilities. So going one step further and moving away a bit from the content of the R&W clauses, I think it's worth spending a minute looking at what the practical issues are. We see certainly a natural conflict between the sellers and the purchasers' interests. Seller wants to have a very short and not complex R&W clause on pensions. Sellers certainly demand very detailed information. So that's a typical natural conflict that needs to be resolved in the negotiations. Then another aspect is that pension liabilities certainly have a lifespan of several decades. So we look at 50, 60, sometimes 70 years, after which liabilities may still exist. And the question always is, can R&W clauses in purchase agreements be a proper tool to actually deal with such liabilities that come up only after a significant amount of time? And then Giles mentioned a good point. Knowledge qualifiers certainly, let's say, decrease the value of R&W clauses. So if the seller, or if the responsibility of the seller is subject to seller's knowledge, it's hardly possible to really prove that they were aware of any existing issues and may be held liable. Then we have de minimis clauses with basket arrangements, we have caps, and certainly the statute of limitations, which typically is very short. So these items need to be negotiated in an agreement to make an R&W clause actually valuable. And then the last point, it goes back to something that Julien already mentioned. Many parties to a transaction, and that may mean both, could be seller and purchaser, take out W&I insurance or warranty and indemnity insurance that should cover any liabilities that are related to R&W clauses in the agreement. But the issue that we face, at least in Germany, is that many insurances exclude pension liabilities from the scope of their coverage. They say that at least the adequacy of pension accruals is excluded, but very often pension R&W clauses from the agreement are completely excluded from insurance coverage. So the value very often of such clauses goes to nothing. And this is why it's most important to identify liabilities and cover them as far as possible in the purchase price discussions.
And very quickly, in Hong Kong, reps and warranties and indemnities are generally along the lines of what Aline and Giles said. So there's nothing really unusual to add there.
Thank you all. I see, we only have about 5 minutes left in our presentation. So I am going to jump to slide 30. This is just a base discussion of HR due diligence. And we in particular wanted to just briefly highlight ESG aspects of compensation and benefit schemes. And I think given the limited time we have left, Hagen, I'm wondering if I can ask you to speak about this briefly. And I know you were going to touch on the EU directive in particular, as I know that will have an impact.
Of course, thank you, Stephanie. Just for background, so ESG is environmental, social, and governance. What is it? It's basically a framework to rate a company's approach to sustainability at different levels. So looking at environmental aspects, social aspects, and governance aspects. Why is it important these days? I mean, the substantive questions, meaning compliance with environmental standards, social standards, and certain governance requirements, they've been around for a very long time, but the topic ESG becomes more and more important because there are extended reporting obligations for companies. In the EU, there's currently initiative underway. It's the EU Corporate Sustainability Reporting Directive, or CSRD, which is going to be enacted in October 2022, actually, that's the plan, and needs to be rolled out by the EU member states and implemented over the next years. What does it lead to? It basically lowers the thresholds for companies falling within the scope of the non-financial reporting requirements. And in the EU, we look at an increase from approximately 11,000 to roughly 50,000 companies that will be subject to such reporting obligations. So, and that is going to be implemented over the next couple of years. In terms of topics, what are the relevant topics when we look at a compensation and benefits context? It's certainly the compliance with minimum wage requirements. It's the approach to equal pay equity, and the absence of discrimination in compensation and benefit schemes. It's the integration of ESG in executive compensation schemes at different levels. So it can mean that compensation can be tied to implementing certain, let's say, programs or sustainability approaches over a certain period of time. It can mean that certain parts of the compensation are deferred and will be paid out only later if certain sustainability objectives have been reached. Another important area is the sustainability of investments made in connection with pension plans. So investors are very focused on ensuring that investments are, for instance, not made in products that are environmentally critical, or in certain industries that use child work or even slavery. So that's one area. And finally, the consultation rights of works councils and unions in the compensation context. So ESG reporting focuses very much on an employer's compliance with consultation information obligations, and looks at the extent and the time when employee representatives are brought into discussions about compensation and benefits.
Any last, comments or feedback from Hong, Eileen, Julian, Guido, Giles? Anything to chime in before I wrap us up?
For France, just one word for France, because it only left 2 minutes, but it is quite exactly the same. ESG matters are now scrutinized very deeply in HR due diligence in respect to minimum wages, gender equality, absence of discrimination, of course, and because also of any inappropriate practices that could impact the reputation of the company. So this is something that we are looking at very closely in France.
And Stephanie, just a quick comment in Brazil, because ESG matter has grown over the past years here. With respect to the context of employment benefits, ESG here related to the adoption of initiatives regarding diversity and inclusion as well. So it's very important in Brazil. I think that in all over the world, but just this comment, there is no law stating any obligation in relation to employment relationships, but of course it's very important to the companies to have these initiatives regarding diversity and inclusion.
Yeah, I think that's something that we're seeing highlighted not just as a legal issue, but as a business imperative for all of our clients around the world. With that, I'm sorry that we don't have time for a Q&A portion. Thank you so much for participating, and that concludes our webinar.